Okay, Illinois State Constitution. Page 4, Article 1, Bill of Rights, Section 15, Right of Eminent Domain. Private property shall not be taken or damaged for public use without just compensation as provided by law. We're talking about sweat equity again. Yeah, reciprocal. Yeah. Or I'm not for sale because I'm a woman. Or just because you want to fuck me. I might want to fuck you, but I'm not for sale. And yes, I should be worth my hire, even in my groin, if I want it. Private property shall not be taken or damaged for public use without just compensation as provided by law. Which means Shane Tyler Propert Sr. should have never been my pimp. He should have never whored me out to society or the family, or those he thought was the family. It was his sons making sure I got paid well. That's their story. And my story is going to remain private because it's none of your goddamn business. Another human right. Privacy. Private property shall not be taken or damaged for public use without just compensation as provided by law. Such compensation shall be determined by a jury as provided by law. Provided by law. God, universe, nature, creation, yes. It's in things, the law. And it screams at you, the land, when you go against the law, when you transgress the law, when you destroy the law, when you give the law death and decimation and desecration. It screams at you, nature, creation, and the universe. And I'm not talking about beings. I am talking about that. Breath. Okay, yeah, law has a breath. Lady Liberty has a breath. Eminent domain is the inherent power of a sovereign government to take property it needs for a public use. This is how the Nazis won over Germany. The United States Constitution's Fifth Amendment, which applies to the states through the 14th Amendment, similarly requires that just compensation be paid if government takes property. But this section goes further and requires compensation if a government project merely damages property. Property within the means of this section includes every interest that a person may have in anything that can be subject to ownership, including real property and personal property. That's why in a lot of nations, when you really truly rape someone or you rape someone to someone else, yes, it is the death penalty, which means off with the head, because that's how evil we've become. People don't die by poison or injection anymore, not even evil beings. Maybe one of their quadrillion will flitter off, so you have another quadrillion years to deal with them. A municipality, having been given zoning power by the state, may restrict the use of property through zoning without paying compensation. That's still theft. But such restrictions on use of the property will not be upheld if a court finds them unsupported by a public purpose or otherwise unreasonable. A rapidly growing issue in constitutional law is the extent to which government can require developers to pay fees or meet other requirements as condition of being allowed to develop land when the fees are imposed for broader purpose, such as avoiding congestion and protecting the environment. Like I live right west of Sunny Acres, yes, in West Chicago. They have tried the whole time Sunny Acres has been Sunny Acres to use the law to steal away their land, the family, yes, so that they can build high-rises there, like Cabrini Green. And when they're done with those people, they'll ship them out further west and reconstruct Cabrini Green, like they did in Chicago. The Illinois Supreme Court, citing both a 1994 U.S. Supreme Court case and a 1961 Illinois case, has held that such impact fees or development exactions are constitutionally permissible only if the need for them is specifically and uniquely attributable to the development on which they are being imposed. Section 16. Ex post facto laws and impairing contracts. No ex post facto law or law impairing the obligation of contracts or making an irrevocable grant or special privilege or immunities shall be passed. This section prohibits some kinds of laws that change the rules in the middle of the game or give a permanent benefit to someone that is not available to others. This goes against your federal constitution because if you're not a Native American, you don't get national land of a Native American in the United States of America. If you're not a diplomat, you don't get diplomatic immunity. But the family is trying to use this to take away diplomatic immunity of diplomats and their papers, and second of all, to take away the national lands that was written by your founders and pre-founders, with the Native Americans, that they could have nations still here among we the people, the United States of America. Study Nazism, study Satanism, and you'll understand their cons, their cunts, and their criminality. Ex post facto laws. Laws punishing persons for past actions that were legal when done, increasing the punishment for past actions, or making conviction for past actions easier are described as ex post facto, from after the fact. The prohibition on ex post facto laws applies only to laws that are criminal or otherwise penal. Furthermore, it does not prohibit the lengthening of a statute of limitations period against persons on whom criminal acts. Furthermore, it does not prohibit the lengthening of a statute of limitations period against persons on whose criminal acts the statute of limitations has not yet expired, or the substitution of information for indictments to prosecute crimes committed before the change in law that allowed use of informations. On the other hand, the Illinois Supreme Court has held that retroactive application of an act amending the former homicide law violated the prohibition against ex post facto laws, since it altered the legal rules of evidence to make conviction easier, and that a change in law from annual parole hearing to hearings only every 3 years could not be applied to a convict whose offense was committed while the law provided for annual hearings. The Illinois Supreme Court in 1994 reaffirmed an 1895 holding that a General Assembly cannot retroactively lengthen a civil limitation period after it has expired on a potential lawsuit. The decision was not based on the section, which, as noted above, applies only to penal laws. Instead, the court reasoning was that the reviving a right to sue after its expiration would violate due process, Article 1, Section 2, by taking from the potential defendant a vested right that was created when the limitation periods expired. The United States Supreme Court has long held the opposite under the U.S. Constitution, and 2 members of the Illinois court dissented from this ruling. May God give us wisdom, and may God give us discernment, and may God give us common sense. Beings on the globe, in our solar system, and in the universe, and eternally forevermore. That means hell and eternal heaven. Peace.